So it's not just bail which is judge-centric. I would rephrase it to say that every decision.
Bail should not be so strictly construed that the state does not have the space to make its arguments.
In any case, a 6 months trial is completely impossible. It is impractical.
A rape case in Uttar Pradesh, where it was done within 8 weeks.
The trial courts have become extremely rigid in granting bail. If the magistrate grants bail, he is under this constant apprehension that I will, social media, the pressure cannot be denied. Delhi District Judiciary, they are active on social media. There are only 34 judges sitting in the entire country, largely supposed to be a constitutional court.
Hi everyone, this is Bhumika Indulia and welcome to our series Echoes. In today's episode, we deep dive into one of the most debated questions of Indian criminal law jurisprudence. Has bail in India become too judge-centric? We explore the theory, the practice, and the tensions that play out from the district courts all the way up to the Supreme Court. We are honored to be joined by exceptional panel today. Shri Atma Ram Nadkarni, one of the most India's respected senior advocates, former Advocate General of Goa and former Additional Solicitor General of India. Mr. Vikramjit Banerjee, Additional Solicitor General of India, a distinguished scholar and exceptional courtroom strategist who brings a rare blend of academic depth and practical experience to complex questions of public law. And Mr. Namit Saxena, Advocate-on-Record in the Supreme Court of India, celebrated author and one of the sharpest young legal minds of his generation. With this remarkable panel, let's get started. Thank you so much all of you for joining us today. Before we deep dive into the larger debate, I want to begin with a fundamental question to each one of you. If bail is the rule and jail is the exception, why do we often feel that the rule depends entirely on judge who hears the case? I would love to hear your initial thoughts on this before we go into the larger conversation or a broader conversation on it. So, sir, can you start?
See, Bhumika, that's a very nice question, but let me start with an illustration. If you take a particular case and place it before, we have now 14, 15 benches in the Supreme Court. If you place that very case before all these 14, 15 courts, chances are that you will get different decisions and not the same decision. So law, the facts, all this is a very static, it's a dynamic concept. There is no static thinking on it. So it's not just the case with bail which is judge-centric. Any matter is judge-centric. For example, if there is a judge who is, capitalist-oriented. You have so many judges abroad also. In America, London, UK, it's well known. Capitalist-oriented. You may have a judge who has been labor-oriented. We have had it in our Supreme Court and various high courts we have had this situation. So similarly, a liberal judge who understands the value of Article 21, who has open notions about certain things, is bound to be liberal. Whereas there are judges who have been public prosecutors, especially, and they have seen it through. So they tend to think differently. You have judges who are conviction-minded. You have judges who are very liberal, who have a liberal approach. So it's not just bail which is judge-centric. I would rephrase it to say that every decision is, judge-centric.
Okay, thank you, sir. Sir, to add to this, sir said that every case is a judge-centric matter. Do you think in bail matters, it is going to be a problematic thing? To add to...
I don't think at all, because every case, as what sir said, especially in cases of bail, requires a certain amount of discretion. Now that conspectus, the width of the discretion depends upon every judge as to what is the width he's going to exercise it. But I don't think there's anything wrong per se. In fact, I think it's extremely important that discretion is considered to be a part of bail. So I don't think per se there's anything wrong.
Okay, thank you, sir. Namit, what's your thought on this?
So I think both my learned seniors are right. But I'll just qualify what Vikram sir said. The discretion is there. That is why it is judge-centric. But no discretion can be unfettered. The discretion is to be judiciously applied. That is where we have principles and factors which are to be considered while deciding a bail application. Now, when we look at how bail applications nowadays practically are getting decided, they're actually very judge-centric. There are principles, a list of 50-odd factors which they have to decide, which they have to look at and then decide a particular bail application either way. Now, what has lately happened, and this is not in the Supreme Court alone. We have 17 benches in the Supreme Court, there are high courts and there are trial courts. What has lately been happening in the country is that instead of looking at, bail as a principled jurisprudence, it is because discretion is involved and the discretion can be utilized either way. Refuse it, adjourn it, accept it. So the discretion should be exercised only on those principles. Although you can't rule out the possibility of discretion will always be there. But those principles are to be adhered. Now, lately what has happened is that the Supreme Court has also developed a bail cancellation jurisprudence. That if those factors are not adhered to, or all of those factors are not properly adhered to, they sort of, they overrule that order, saying that this order by which bail is granted is not correct in law. So the bail cancellation jurisprudence is already, also being created. Now, it has a chilling effect. It goes down, it percolates downwards to our trial courts, and they have, started believing that largely we have to refuse bail because the Supreme Court under Article 136 granting bails and Supreme Court, has a larger jurisdiction because of it is empowered by, by Article 142 as well. So instead of looking at it as a principled jurisprudence, it's judge-centric, and therefore we have to refuse bail and let, it travel, vertically up. So that it needs a relook in that fashion as well.
But is Supreme Court following all those principles?
See, again, as Nadkarni sir pointed out, 17 benches, all of them, they come from different high courts, they come from different backgrounds. Somebody may be a criminal law practitioner. Justice Nagaratna recently said that I never decided any bail application when I was in the high courts. And now in the Supreme Court, I'm deciding bail applications only. It is consuming a lot of my time. So they come from the different backgrounds, different readings, different understandings of society, because the criminal law is basically law and order. So they decide it in a different fashion. So it is, in my view, very judge-centric.
Okay, thank you so much, Namit, for explaining this so beautifully. We will talk about it with some instances probably at a later stage. But I want to understand from you, sir. You have a great exposure and serving as a Advocate General of State of Goa and then Additional Solicitor General of the Union. Delays in criminal justice administration is not arcane knowledge. In your experience, where do delays most frequently occur in the criminal proceedings?
See, the first thing is when it comes to detection of an offense. It's done by a long drawn process of investigation. Okay. Now, for example, when I was ASG, there was a petition which was taken up by a bench of the Supreme Court. One of the suggestions that I had given was that the policeman should always have a body camera on him so that you know what is happening. If you go to London, you go to Austria, Australia, everywhere, all the policemen, they always have a camera on their head, in their cap, they have it on their belt, they have it on their neck, everywhere it is there. India is, unfortunately, we have concentrated on so many other things rather than this. Number two, our police officials, the very police official investigating a most important offense is also posted for VIP duties. Is also posted for law and order duties, for bandobast duties. It is waste of his time. The very officer can't come and depose in time. So today you have in a murder trial, you have somebody being examined today. The next witness will come next month. Sometimes in other courts it is after 2 months or 3 months. So these are all things which are, you should have, and the Supreme Court has said it is not just one, but around 3 or 4 judgments they have said that segregate the investigation team and the law and order team. This police branch should have complete separation of this, which is not there. Then when the charge sheet is filed, thereafter there is delay because the judicial delay areas, you all know, our judge population ratio is not the same thing. So then there is this one. Much of the time is taken for a bail application. Sometimes the bail application is heard for days together. Order is reserved. You have recently, I think Justice Pardiwala's judgment where he observed that the judgment had been reserved on bail for about 3 months, 1 year or something, or 6 months. Very unfortunate. I mean, bail is something on the spot, you either grant it or deny it. It can be denied if that person, is going to temper, he has got a history, antecedents of crime, and if that person is a first-time criminal and the investigation is done, only question is whether you temper with the witnesses or no. You can put down strict conditions. You can even avoid the case of flight risk because your passport can be taken, suspended, deposited and all those things. So the areas is, there should be simultaneous efforts by everyone. The lawyers, the judges, the prosecutor and more particularly the governments, which should bring in reforms, because otherwise, today, many a times what happens, there are cases where criminal offences take place and people say, "Arey wife, chodo yaar, we will not complain now because every time you'll have to go to the court and depose and all that." So that should not come to that, no? And ultimately in this country, amongst all the institutions, fortunately till today, courts are the only institution where people have faith, which also is getting shaken day by day, but very unfortunate.
The judgment which you're talking about was reserved in May last year and it was pronounced just 15 days back. So what is your say on this, that if you want to add something to Sir's answer?
My addition is a lot of this is taken criticism. But however, I would say Sir has obviously seen the BNS. The BNS on those two issues which Sir spoke about, I think that have been more or less been addressed. They've tried on various occasions to set down strict timelines in which it has to proceed. And I think body cam is also investigation will have to be now recorded by camera whenever investigation is happening. So I think broadly those are being tried to be addressed. Those are live issues which we know anyone who's been involved in practicing of criminal law is aware. Now the other question which I think Sir spoke about is that there will obviously be some delays. And the process of delays is not only due to the state, but it's also due to the parties, the other side concerned. This is my experience. And in the other, and the fourth point I think which Sir raised and which I think needs to be also addressed is bail should not be, and here I slightly differ from Sir, bail should not be so strictly construed that the state does not have the space to make its arguments. Because there is also a possibility, and which is I think both of us have seen because we've been in a similar position, that in many ways sometimes the court also errs, and I would say this, or errs is a strong word for that, but the court also moves towards being very liberal in certain cases where there are very strict concerns of the state as to the person's activities, the person's impact on society, which are considerations, but which are again not taken into account. So I think to sort of to say that the state's concerns are not valid concerns in many ways, I think I'm not on the same page as Sir on that.
Right. Thank you so much for...
I never said state's concerns are not valid concerns.
But
I said whenever in a given case, a case is made out for denial of bail, deny the bail. But a case has to be made out.
Yes.
A person who has antecedent, that is a murderer, committed 8-10 murders. If the next murder, of course you're not going to give him granting.
No, but I think the crux is, these are very clear things. I think the crux is where people would obviously have some impact on public order, and in some ways are concerned, they would have corruption, powerful people having corruption cases against them. They would then, if they are let out, would be able to clearly, even though not directly, indirectly be able to influence the course of the trial. What do you do in those cases? So I think the state is to that extent valid in saying that no, it has to be strictly construed and there has to be, you have to push those conditions strictly. The other side is, of course, everybody has a right in law to argue on the other side. So, but I would say that concern of the state is a genuine concern. That very powerful people, if they get bail, if it's a straight murder, eight people have been murdered, then that's...
If they are so powerful, they won't be caught in the first place.
No, but...
And that also is a reality in this country. Don't forget that.
But I don't agree with that at all.
No, you don't agree because... See,
I don't agree with that at all.
Mr. Banerjee, you don't agree with it. It's not a question of your agreement.
No,
it's
I'm
a
just
question of the reality of the day.
I think that people there is a genuine concern.
But sir also pointed one thing that delays, in some cases delays are okay. This brings me to my next question, and I want both of you to answer this, that justice delayed is justice denied, but recently Justice Suryakant pushed for something, basically completing a trial in a heinous case and national security cases within 6 months by working day and night. Do you think in your vast experience it is practically possible if you are hurrying?
No, I think it is highly impractical. In 6 months, it is only in theory that you can actually, achieve 6 months trial in NIA cases or in, heinous cases, or rather in NDPS cases also. Because, for multiple reasons. It is not, see, all of us are equal consumers, in this justice administration. And, the bar plays a role, the prosecutor, the defense, the prosecutor, the investigating officer, everyone plays a role. Now, see, that idea of 6 months, now assume a scenario in Rajasthan, where an investigating officer in Jaipur, investigated a case, and thereafter he's transferred to, say, for example, Bikaner. It will take him around 1.5 days every time to come to Jaipur to give evidence. It is actually not practical that 6 months, even if you consider day-to-day trials, 6 months you will have around, I think, at least 40 odd holidays, Saturdays, Sundays, judge will be on leave, some duty, some judicial training, something or the other, lawyer is not well, the witnesses don't turn up. 6 months is not practical. But, coming to the previous question, I'll just add one more thing what Mr. Nadkarni and Mr. Banerjee pointed out. Mr. Banerjee pointed out another timelines given at the BNSS. There is one very important timeline which they have missed. That is filing of charge sheet. There is no timeline prescribed for filing of a charge sheet. Unless the accused is in jail. It says that 90 days or 60 days as the maximum punishment prescribed may be, he may be or she may be released on bail. But there is no timeline given to actually complete the investigation and file the charge sheet. Now, recently, Justice Sanjay Karol's judgment has come, in which he has pointed out that this long delay in charge sheet is also, one of the factors for quashing of the FIR. If you are taking, so long, then you don't have anything to investigate further. You'll quash the FIR itself. So this timeline, is, in my view, has been missed. Although a lot of timelines have been given, but this has been missed in my view.
Right. So what is your say on the justice delayed part, which sir mentioned that it is okay, and the other side is Justice Suryakant actually pushed by working day and night, as I said?
No, see, I fully endorse what Justice Suryakant has said. Having taken over as the Chief Justice of India, the thought is in the right direction. But there's also practical, pragmatic difficulty. As he rightly says, it is impossible, not just difficult, impossible. See, today the situation in our country is the trial courts take 6 months to decide an injunction application. They take 3 months to decide an amendment application. A listing of a matter before certain division benches of certain high courts almost takes about 2 to 3 months for admission. Very unfortunate. Delhi High Court, you get it immediately. Supreme Court, you get it within 1 or 2 days now, if the defect is cured and all that. But this is a practical, pragmatic difficulty. I also endorse what Namit has said, that, officer, by the time the investigation is just done, before he files a charge sheet, he is transferred somewhere else. So who will carry on with that work? The investigation is a very dedicated thing. You need, because you have seen, the number of witnesses, who has deposed what, etc. So it is 6 months is a very, good luck. If we can do it in 6 months, nothing like it. But it seems to be far from reality.
But we are not talking about the pendency of cases and the time which is taken. It's always pending because we are not following a particular timeline. That's why we are missing out on the deadlines also.
See, I'll tell you one example. Now, under the new law, after charges are framed, you have a right to file a discharge application within 60 days. 60 days is roughly 2 months. If you file on the 60th day, they'll call upon the prosecutor to file a status report, or the victim or the complainant, they have equal unbridled participatory rights now to file a response to it. A date will be given, after 1 month. 3 months are gone. In any case, a 6 months trial is completely impossible. It is impractical.
Right.
Though it was done in the Supreme Court ordered it in case of that rape case in Uttar Pradesh. Unnao somewhere. Where it was done within 8 weeks.
Well, then you'll see
But
section
the media
35.
attention is also taking some kind of a responsibility in this that trials are being pushed because if a case gets media attention.
No, I don't completely agree to it. Although I'll tell you one more thing. See, section 35A POCSO is there. It says 1 year. POCSO is again very heinous offences. It's a sexual offence against a child. That says 1 year. Preferably within 1 year, it says. So the 6 months is neither here nor there. It is very good in theory, but
the effort, thinking in that direction is really good, because if you say 6 months, chances are that it will happen in 1 or 2 years.
Within 2 years.
And I think what you're saying is that speedy trial, of course there should be speedy trial. I think that's a push towards having speedy trials. There can be no question about it that we want speedy trials. Because as was always discussed, even when the time of introduction of the BNS, that the process should not become the punishment. So that's what is behind it. And I fully appreciate what the Honourable Chief Justice has said, that there should be a push towards speedy trial. And it's worth seeing whether you can do it. May not be in every case, but in as much as you can do. Because now the trial tends to, as all of us know, for a long period, very, very long period of time.
Right. So, having served as an additional Solicitor General from past few years, what major changes you have seen in the criminal administration system in the country in the last decade?
Well, I think the most important is BNSs. And the entire gamut of laws have completely been changed. I think timelines have been fixed. I think technology has been brought in. I think whatever we have seen, I think there is going to be, in many ways, a sea change. It required an update, no doubt about that. And there is always scope for development, for change. There is also no doubt about that. But the fact is, in many ways, and the litigation has not come up, BNS, I think, is complete game changer.
Right. So you have handled a lot of sensitive cases and in the context of high profile and sensitive matters. How can the system balance public interest, media coverage, and the accused right to fair trial?
See, we actually do not have the so-called American system of trial by media. Media gives a lot of attention to a case, but fortunately, our judges are robust in their common sense and knowledge of law. I do not think, it may happen in a rare case, that a judge is a little hesitant to equate or whatever it is, changes his approach because of the media attention that a case has got. So fortunately in our country, maybe because of the training of judicial officers or whatever it has never affected. There are cases where media has given a lot of attention and there has been an acquittal. It has happened, so many cases, high profile cases. Nithari case, what all publicity, it was virtually like a conviction by the media. But of course, media has its own right. They are a third, state of the country, and the media also is required so that the people know what is going on, etc. The accused has his own right, and accused has a right for speedy trial and a fair trial. Most of it is a fair trial. So all those are part of it. But in our country, fortunately, the judiciary has been, with their robust common sense and knowledge of law, they have done a fairly good job insofar as criminal matters are concerned. Of course, you have judges who are overtly strict and conviction minded. That is there. That all of us have seen. That is from magistrate till the Supreme Court. You have all those things. But that's okay. That's that's the ideological setup. And after all, administration of justice is a part of that. Ideology is an integral part of it. There's nothing wrong with it.
Right, right. Thank you so much, sir. Namit, you are currently serving as a standing counsel of UP, Special Public Prosecutor for Income Tax, and also SPP for ED. How do you assess the gap between the theoretical concept of bail and the why bail is actually handled from the district courts to the Supreme Court? And I hope you will give a free opinion away from the bias, without any biasness, because you are handling so much
No,
from
of
the
course,
government
of
side.
course. See, theoretically, bail is what? Bail is that custody of one person is handed over to the surety. Custody of person from the court, that is judicial custody, is handed over to the surety. That as in when you're called upon during the investigation or during the trial, the surety will ensure that that person, attends the court or the investigation. That is largely bail. Now, what has been lately happening is, in my view, particularly, the trial courts have become extremely rigid in granting bail. If the magistrate grants bail, he's under this constant apprehension that I will, have to face some blame either by my seniors, or if it's a sensitive case, by the media, or by, social media. The pressure cannot be denied. And a lot of sitting judges, in Delhi District Judiciary, they are active on social media. So there's this undeclared pressure which is always there. So trial court particularly, and I've seen, trials by magistrates, they also deny bail, despite the rigor of 437(6), etc. Now, when you come to appellate courts, so there is this general apprehension in the minds of the convicts also, that, or under trial prisoners also, that we'll get bail or suspension of sentence, as the case may be, only from appellate courts. That is why you'll see largely, Supreme Court's burden of bails has increased tremendously. Because, see, for example, NDPS cases where you have the rigor of Section 37. Now, 37 has been interpreted in a certain manner in a lot of judgment, Mohit Agrawal, etc., that even for the high courts, it has become very difficult to grant bail in 37 because of the, although 37 is a bail granting provision, not a bail depriving provision as such. But then all these bails come to the Supreme Court only, and the Supreme Court, grants bail because they have undergone so many months and years of incarceration. The trial is not proceeded for, etc. So in theory, bail is a simple concept of criminal law. Give the custody to the surety or on a personal bond, as the case may be. In practical aspects, bail has become very difficult from the trial courts, particularly till at least the district judges. And then if there are special courts, to the special courts as well. High courts also, see, because what lately happened in last few years, if you'll see, and a lot of judgments by those sort of particular benches where Justice M.R. Shah was a part of those benches, Justice Chandrachud was there, Justice Nagaratna was there. Now they developed this Ramesh Bhavan Bhai Rathod, etc., all these series of judgments where they, bail granted by the High Court, discretion exercised in a particular way, they cancelled the bail, directing the accused to surrender immediately. That had a very chilling effect, and that chilling effect will take a long way to go because of this pressure. Now, see, all High Court judges, they are also to a certain extent, they're aspirational. They don't want to be in the bad books. They don't want, because nowadays they know there is a judgment evaluation committee in the Supreme Court as well. Their judgments are being evaluated. So they don't want their judgments to come to the Supreme Court and then get overturned because they exercise their discretion in a particular way. So they're also very wary of granting bails so that is why the pressure is on the Supreme Court now, and there are only 34 judges sitting in the entire country of 160 crores. They have, they're largely supposed to be a constitutional court, but it has become a bail court. Similarly, in matrimonial matters also, it is all coming to the Supreme Court, 142 grant, for whatever reason.
No, I think what Namit is saying, but I have a slightly different take. Because when you have NDPS, the way Namit interprets it, to me, the bar is very strict. And the Supreme Court has actually in many ways diluted that bar. So when effectively the bar is very high and then you dilute it, only the Supreme Court can dilute it in that effect. So the hands of, and that's not only in NDPS, there are other statutes like the UAPA and things of that sort, where the bar is high. But there is, and only the Supreme Court, and I think rightly, the Supreme Court knows and has appreciation of a lot of different facts.
But do you disagree with the fact that trial court judges are living in fear while granting bail and while exercising discretion?
I don't know. This is an apprehension which I see quite...
And there has been the statements
which I see
being made.
Quite spoken about. But I really don't think so, because my experience is people have exercised what they think under the circumstances. they should exercise. Now, as I said, now one has to appreciate that when one is in the trial court, one's hands are much more tied than when they are in the Supreme Court, because Supreme Court, as the higher you go to a high court, go to the Supreme Court, your discretion, as I said, what you can do, the tools that you have, the provisions that you have, the powers that you have as being part of the court that you have becomes wider.
So, sir, please tell me, sir has a different opinion about trial court judges on living in fear. What is your thought process on this?
No, see, just don't relate it only to the trial courts. The trial courts, as well as the lower appellate court, like the sessions court, as well as high courts. Take the cases of PMLA. Supreme Court has said it, that what is happening to our high courts, why are they not releasing? Supreme Court has granted bail finally. See, Satinder Until is a classic case where what Justice Sundaresh said, even after that, the courts were not granting. So Justice Sundaresh has passed further orders saying that why asking for explanations from the special courts, why are they not following the judgment? So that fear is something, if you ask me, if the judge has to give his decision under fear, then such a person should not be inflicted on the population of this country a day further. Because each of these trial court judges who are under fear, or high court judges, they have a service of about 10 years or 15 years. I mean, the constitution doesn't, this one, whoever knows Article 21. At the same time, it doesn't mean that every bail application must be granted. Every bail application must be decided at the earliest. That is the law. Number two, it is not a rule that a bail must be granted in every case. That is also not the rule. Bail can be denied and a person can be put behind bars, continued as an under trial prisoner if in certain offences. But certainly not for anything and everything. When in a country like ours, a trial takes about 5 years, 10 years, you have accused in custody where these financial scams, etc. They are there in custody for 8 years, 10 years. And the charge sheet is yet to be filed. Investigations are not over. It's all a matter of documentary cheating. So you don't require them inside for such a long time. And what tomorrow, if there is an acquittal, what will you do with this 8 years, important years of life which they have lost? So it is a fact that there are judges who live under fear, but of course you can't generalize that 100% judges are under fear. See, the fear is coming from different. Fear is basically something which is a matter of subjective obligation. It can't be put to objective tests. It is because of the mindset of the judges. Some look for their promotion, some fear their transfer, some fear reprimand from the appellate court. So all these are different things which go. If you ask me, a judge, these are genuine fears, but a judge must be fearless.
But then we have seen the instances that someone questions their hard work, that why they have applied their discretion or exercised their discretion. So they shouldn't be having this fear. That is what I'm saying, that why they are living in fear, because of certain instances which have happened in the past.
It could be because of instances, it could be because of their psychological thinking, mindset which is there. So all these things are there, but despite all this, they should know that they are they are participating in the justice delivery system, which is a very, very sacrosanct function. It's almost like a divine function, because you are supposed to give justice to the people. And if you are supposed to administer justice, and if you do it under fear, then there is no worse thing than that. It's not a mere question of, deciding a bail or not deciding a bail, granting or rejecting. I'm not on that. I'm saying if you are in a justice delivery system, it must be fearless. I mean, you decide whatever is right, whatever your conscience tells you. I have experience of umpteen number of High Court judges and Supreme Court judges. They are completely justice oriented. Even if the law is against you or in your favor, etc., relief can be denied or a relief can be granted. There are cases like that, because the situation, circumstances requires that particular order to be passed, and that is where the real justice would be served. So you can't just bring in law and make a technical argument that it can't be granted, etc. So there are judges who are very bold, who are very, very forthright and liberal in their approach.
And they are transferred every...
Doesn't matter. They could be. That's a reality. They could be transferred, but I'm glad that the judge, despite several transfers, has not played any heed to anything, and is very bold.
And
Thankfully, such type of judges must multiply in our country.
No, I obviously, to that extent, I have my little bit of difference. I think, as I again said,
Banerjee is bound to have reservations on many things. I can understand his position.
But I'm just saying that it's, to my experience, that they are trying to do a job and they don't have, and again, this is something which I keep on repeating, they don't have as much discretion, because the higher you go, the more discretion you have, because the Constitution in some ways provides, and the statute itself provides for more discretion as you go higher up the chain. So to that person, under the law, which is, he has to strictly apply it. So he applies it in the way which it considers strictly. So it's not that he's not granting bail. He is granting bail when the circumstances which demand that he grants bail. But you can't judge him by the standards of a higher court. The tendency for us is to judge him by the standards of a higher court. Like saying, if Supreme Court grants bail in this case, you should have granted bail. But my answer to that is he has certain structure under which he has to function. That's the structure laid down by the law, which does not have that amount of discretion. So you can't blame him. He's taken that decision. And it's wrong to judge him as conservative or strict, because he tends to go with the law which is strictly in front of him. Now, technical decisions, as you go higher up the chain, don't make much of a difference. Because then they can say it's a technical decision, it's a technical argument. But if it's a legal argument at the trial court level, then it's a valid argument to take. Because, you can't say you don't have the power. The trial court judge doesn't have the power to do that. To me, my understanding is, of course, we are all human. We come from society. We have all our likes and dislikes. And I like someone and I don't dislike someone. That's human. And that may or may not transfer, but people at the transfer to the cases which you handle. But to my understanding, people who are doing their job under that amount of pressure in the trial courts all over the country are trying their level best to deliver justice under very trying circumstances. And, they are trying their level best to conform to everything and to deliver justice to the last common person. So, yes, there are people and there are people, because we exist in a society, but it cannot be generalized that they are in fear or they are acting out of fear. I disagree with that.
Right.
So all judges are bold. And no, there's not a judge with fear.
Every person is every person.
Nobody has generalized. All that we are saying is there are cases where judges have lived under fear.
Everybody's human. I fear for so many things in the world, but that does not mean a thing. It doesn't mean that I will translate it into my judgments when I pronounce it.
But it is being translated.
But that's anecdotal. Most of the stuff which I've seen is, it would have, it's anecdotal, it should have. And everybody judges by, as I said, you judge it by what the Supreme Court has decided or the High Court has decided. Of course, the High Court has much more power. There's a 482 with the High Court. There are so many, much more discretion, 142.
Supreme Court is being overburdened for this reason only, that they are not exercising their powers.
But that's what
This takes us to our first point, principled or judge-centric.
That's right.
Or it may be another thing, because people think, and I think, working with criminal practitioners who worked in criminal law, people definitely think that they have a better shot in the Supreme Court. Because even if you think that some parts of the law may be against you in a lower court, the higher you go, you have a better shot. That's on the other side. Because you may be able to highlight those portions which are, and take a little bit more advantage of discretion which the high courts have. So that's part of the strategy. We all know that. We use that. So now, you cannot generalize it and, hold the trial court judges responsible for that. They're trying to do difficult job under very trying circumstances.
Right. Namit, we have spoken about being judge-centric, the bail is being judge-centric. It was even said that during Justice Bela Trivedi's tenure, bail outcomes reflected this trend. And so how do you want to respond to this perception?
So I'll take a cue from what Mr. Banerjee pointed out. The higher you go up, there is more discretion. But in certain cases, it happens to the contrary. See, the higher you go up, and if you're particularly from the lower judiciary to the High Court, then to the Supreme Court, you have to shed off those shackles of completely being bound by the procedure and completely being bound by precedent. As a Supreme Court judge, you are the precedent. You are the law. Every Supreme Court judge is a constitutional authority in himself or herself. So you need to understand that power. And I'll take another cue from Ramayana. See, in Ramayana, Hanuman was very powerful. But it took a Jamvant to make him realize that he is very powerful. I think in Justice Bela Trivedi's case, it is also a collective failure of the bar. The bar is the Jamvant. The bar failed to let her realize that she is now a Supreme Court judge and she is empowered to grant bail or to grant relief in that fashion.
Fantastic.
So, but it is what it is. A lot of her judgments, and now there is a
I have my differences with that. I think what she did was go by the letter of the law, and you cannot say that the obligation of the judge has to be liberal. A judge can be and should have the discretion of being conservative. The entire thing, the approach is, no, we should, the judge should be waken up to be liberal. The judge can have a conservative interpretation of the law and can believe, as Sir said, you have your own, you can call it ideology, you can call it your own perception of the law, but you should have the ability to interpret the law in the way you think is responsible for delivering justice. You cannot say, no, you should have had an expanded interpretation. That's what you think. You can't have it both ways. You can't say, no, they should have a liberal interpretation. And also, on the other hand, say, why are you using discretion when that person disagrees with you?
They again come back to point that bail is a rule and jail is an exception. But I think probably there was some disagreement with this statement by Justice Bela Trivedi.
So, I personally think that the person can agree with that and also take a very conservative look at your approach to the law. I know for a fact that in many ways, while interpreting the law, on very many ways, I have a very conservative approach where I believe, and this is my view, and I'm not saying, I personally believe that the judiciary should be conservative, as hands-off as possible. Classical old common law jurisprudence that, our job is just to interpret the law. The Honorable Supreme Court differs from that. That's a separate issue, but that's my view. People may have different interpretations of it. People may have different ideas as to approach of the law. You can't then say, no, it is, they should have been woken up to be a liberal. I think that's, she was right in many ways. In sometimes, I've been on the other side where sometimes she's been very strongly, she's come down on me. And I'm taking because the name was raised. But I think at no point of time can I ever fault that she was not doing justice. And a lot of these things which are usually raised is because people don't agree with the conclusions which she came up with. I think that's completely unfair to her.
So what
I
is
think
your
even
thought?
Judges didn't agree to certain of her conclusions. Bhushan, Par and Steele. The judges of the Supreme Court also did not agree.
So you have to say something on this.
About what?
About how the perception was on Justice Bela Trivedi's denying of bail in most of the cases.
No, it's not that she was denying bail in most of the cases. See, she was a judge of the High Court. She had been a judge of the lower court also. So it's not that she didn't know the bail jurisprudence. It is that the approach was conservative. The approach was not conservative as such. That was her way of thinking and her way of putting. So you can't find a fault with the judges because the judge has a particular mindset. See, I'll tell you, there was a matter which we argued before Justice Bela Trivedi. The way it was going on, I told her ladyship that I'll argue this at the end. because this is all, it was all cacophony. What happened was all those petitions of the Union of India were allowed. In my case, and one more where Mr. Siddharth Luthra appeared, those two petitions were dismissed because we showed the facts of the case. It was not, you need not, so when the judge is convinced about it, 45 other people were just in that queue arguing. If you start with the mindset that the judge is against you, how will you argue a matter? So, see, we are also a part of the justice delivery system. Even we don't attribute any knowledge to the judge before we go, because sometimes what happens with the judge asks one question, we get rattled with it. That should not be. How will the judge decide unless the judge is asking?
Absolutely.
Maybe the judge is hostile, but it's always nice to argue before a hostile judge. It's our way of persuading a judge. So I'm not saying about the conservative approach.
Why was this perception about her? About Justice Banerjee?
No. The perception was that she was a very strict judge. For example, she said this 10 pages of the Supreme Court orders are only appearances. These lawyers are never there. And so you can't find fault with that judge for that. It is true. The first 10 pages were like that. But other judges didn't bother about it. They were concerned with the remaining pages. So what I'm trying to tell you is that you can't condemn a judge saying that, because she did a good job, she delivered so many judgments, right or wrong. If a judge can decide rightly, you can decide wrongly also. We were on the approach, the principle. We were on the topic whether the bail is strictly in accordance with law or it is judge-centric. To that I said, law is common everywhere. It's the application of that law which differs everywhere. It could be because of your experience, it could be because of your ideology, it could be because of your understanding of Article 21. These are all things which are there. So the constitutional genesis of the whole thing is that how you read a particular matter. So that is how, how it is presented to you, how it is shown to you, how it is argued, and how ultimately the judges decipher the whole matter and then decide. See, is it not a case that for granting bail, two judges have differed? One says grant bail, other says don't. It's not that both are wrong and both are right. It's not like that. The judges have taken a view. You must concede the fact that they have a jurisdiction to decide rightly, then they can also decide wrongly. And Supreme Court is the final court, therefore there is no further appeal than that.
Coming to my last question to all of you, and are we defending liberty or defending a system where personal philosophy outweighs legal principle and bail decisions? So, would you like to say something on this? As a final...
I think if you're talking about bail balances both. I think you cannot have, that's my personal view, cannot have only a liberty-based jurisprudence in bail only, because you have to balance it with, and I've said this a number of times when I've argued matters. For example, in the NDPS matter. When you are letting people go on NDPS, they have huge impact. I have seen my friends getting affected by NDPS. So, it's no doubt that you should have liberty. But on the other hand, it is also the state, the society should have a say. And it's the balancing of both interests. And I once said to me, to everyone, to any judge, and I'm not talking about any person. NDPS bail may be just an NDPS bail. The person has been in jail for a long period of time. There's a small amount of quantity involved. The person should get bail. But I have seen my friends getting affected. And to me, I take it personally. And I think that it should be balanced.
So your thoughts?
See, between liberty and personal philosophy, it obviously is the liberty which must prevail. Because liberty is something which is enshrined in Article 21 of the Constitution, and Article 21 is like a heart of the Constitution. So you can never deprive the liberty of a person. Umpteen number of judgments of the Supreme Court, and the law and the constitutional philosophy is towards liberty. You have to leave your personal philosophy aside. Okay. Now in matters which Mr. Banerjee gave, that if it's a drug case, person has been languishing in jail. Now there the question is, suppose if he is, accused of taking a drug for personal consumption and not a peddler, If he's a peddler, then obviously the parameters would be different, because a peddler is the one who is selling drugs and affecting society. Banerjee's friend who is affected is because of the peddler who was doing it, not because of the individual consumer. What will you do? He went for a holiday somewhere in some place and he found it, and like a sitting duck he was caught. Is this drug menace something you think the system doesn't know it? It's now that the government is coming down very heavily on it, because now people sitting in the government have realized that drug is something which is, are there not states in India which have rampant things happening?
Punjab, Haryana.
Exactly, he said it. So what is it? I mean, ultimately we all have concern about it. So, but liberty and liberal approach is something different. I'm not saying that because liberty is the sacrosanct thing, when a person applies for bail in a heinous case also, he should be granted in the worst cases. No, obviously not. Who's telling you? I mean, if someone is a cold-blooded terrorist, would you grant him bail, applying the same principles which you grant for other matters, regular matters? Obviously not. So whether a bail should be granted or not, but the bail application must be decided at the earliest, and the bail application must be decided within the parameters. At that stage, you can't take it that he is already guilty of the offence, now let him remain inside as a part of punishment. That should not be. It should be for the purpose of that he doesn't deserve to be given liberty, because there is a larger danger to the society if this man is released. So it is better between public interest and private interest, let the private interest suffer. That could be the principle, on which, because of his antecedents, etc. But the liberty is something, there can't be anything which can, compromise when it comes to liberty. But that's the most sacrosanct thing. And by the way, all our philosophy, the Indian philosophy especially, the Indian ancient philosophy also speaks about liberty, not regarding confinement.
Right. Thank you so much, sir. It's very beautifully said. Namit, your thoughts?
As Sir said, liberty, personal liberty particularly, is constitutionally guaranteed. It's a fundamental right. I don't think in questions of liberty, personal philosophy should play any role at all. It should be completely principled. Every case, facts of each case, they should be decided on the basis of the principles which are being decided, by the Supreme Court in multiple cases. Those principles should be applied, whether it's a heinous case, NDPS case, UAPA case, PMLA case. On the basis of each set of these cases, those principles should be applied. I don't think this element of personal philosophy should not interfere with or tinker with this justice administration at all.
Right. Thank you so much, all of you, for giving your time. It was a fantastic discussion. I personally had a great time talking to all of you.
Thank you so much. Thank you. Thank you, Bhumika. Thank you, Vikramjit. Thank you.
Thank you, sir.